Good morning, Your Honors.
Good morning.
I'm Charmaine Nichols from the Knoxville Bar. And
Ms.
I would
Nichols,
like to-
please stand over in front of the microphone and pull it
I'm
down.
so sorry.
Thank you.
And I'm part deaf, and I had a hard time hearing. I should have thought of that. I'm sorry. I'm Charmaine Nichols, and I'm pleased to be here on behalf of Mr. and Mrs. Franz. And I would like to reserve 10 minutes.
How much?
10.
We don't usually do that.
I mean, I would like to do 10 minutes and reserve 5.
Reserve 5, that'll be
Pardon me.
fine.
Bear with me 1 second. I'm so sorry. Do this. And I would like to thank the court for the indulgence on the continuance I needed for my prolonged illness, which has also resulted in losing some hearing, amongst other things. So thank you very much. We're here today on behalf of Mr. and Mrs. Franz, and the reason is this motion for summary judgment that the judge granted, but unfortunately did not follow the well-established rule for assessing duty, breach, causation, and in fact failed to apply the elements to this case, to the facts to these elements. In January of 2020, Mr. and Mrs. Franz moved into a townhouse that his wife had found. He had never seen it. He saw it the day they moved in. And at that time, the International Residential Building Code in Caryville, where they lived, was already in effect. This townhouse was 2-story, and the only means of egress and ingress were these stairs. I did blow this up as best I could because the one in the record, if you would like, this is a little better. The one in the record is pretty dark, but
Have you seen it?
if you're
Seen it?
able, can
You
I
seen it,
finish?
counsel?
Yes, he's seen it.
Okay, yes.
As you can see, these first 5 risers at the very top have no handrail. So if you're going up, you have a handrail the first 9 steps or so, but then you don't have one. In our case, Mr. Franz was going down, and there is nothing there but the wall as you traverse the steps downward. And unfortunately, on June 15, Mr. Franz was getting ready to go to work, go downstairs for his coffee, and he fell to the bottom of the stairs. As he went down, he lost his balance. He reached out. He testified in his deposition. He reached upwards because he's a kind of tall man. He thought maybe he could reach the roof. But I think, as everybody in this courtroom knows, a handrail is very important, and the handrail code required that it run the entire flight of stairs. Now, the court and all the parties know and have admitted this is a breach. This is a very relevant breach because it created a defect and a hazardous condition for these people who live there. And Mr. Franz, he's not a builder. He did not know. He did not appreciate the danger. I think that's fair to say. But the importance of this, and it's in the plaintiff's expert report, Todd Duncan, very respected by both sides of the bar, opined that this handrail eliminates the ability, the lack of one, eliminates the ability for the person to regain their balance. And I think we all know that there's a possibility of losing your balance for any reason. It doesn't matter what the reason is, but you could at least catch yourself. Maybe you start to fall and you can mitigate the fall if you could hold on at some point. And as the testimony shows, he went down, he suffered serious injuries, ultimately had to have spinal surgery. The third element that the court looked at, or failed to look at, I should say, was comparative fault. And comparative fault requires you to take a look at several factors. One is the magnitude of possible harm. If you stand at the top of these steps and put yourself there, it's pretty apparent that there's a danger if you fall all the way down. The second factor is the importance of the defendant's conduct or social value. and then the feasibility of an alternative conduct, the usefulness of safer conduct, and the last two, how feasible. It's hard for me to get my head around. You're building a townhouse, spending a lot of money. How much money for 5 more steps for that handrail? How much money would it cost? It's highly feasible, maybe a couple of $100 at the most, and we wouldn't be here. So the court, when they discuss these cases, the case law, we don't have a problem with. The problem is applying these factors, and particularly with regard to the comparative fault. I think the court glossed over that, and they brought their focus onto Mr. Franz. The court did not apply anything to the defendant except to say that he didn't follow the building code. And I think that therein lies the problem with the ruling that we got. Excuse me. So the analysis of foreseeability. It's highly foreseeable when you have a set of steps anywhere that you might lose your balance and fall, and that's why we have a code in the first place. They want to protect people. They want to protect people in public buildings, and they want to protect them in their rental homes and so forth. And the Supreme Court, I don't know why in the world, but I did not locate this case until we worked on our reply brief. And the 1979 case is as spot on as you can get. This is Overton Square.
Counsel, is this case in any of your briefs?
Yes, sir. It's in the reply brief.
It's in the reply brief.
Right. And I
Go ahead.
apologize, it wasn't in our first one, but it's one of those unmagical things that happens when you do research. But it's as close to being on point with this case and the problem with the underlying court's ruling in that one. And that is, this lady, the plaintiff, is at a restaurant, and she's at a landing. She's coming in the back door of the restaurant, and all of a sudden, she loses her balance and she falls down. That case, like this one, had a building code. The defendant did not follow it. And the building code required that because of the width of where she fell, there was supposed to be a handrail in the middle. And defense counsel persisted with this particular plaintiff and said, well, once you admit that the handrail, you could have got your foot caught in it or you could have hit your head, like it was okay to disregard the code. And her answer was, no, the middle rail might have let me grab onto it. And that's exactly what we're arguing here. The rail, maybe he would have lost his balance, maybe he would have gone down 3 or 4 steps, maybe he could have stopped himself halfway, but that did not happen. And the
Counsel,
court...
excuse me, did you allege negligence and sorry, and negligence
I'm sorry, I can't hear you.
What was your allegation in the complaint? Just negligence?
It's underlying negligence, yes.
And did you
And
also,
negligence per se.
That's what
Both.
that's what I was trying to
Yes,
get
Your
at.
Honor.
Thank you.
And that's in the original complaint. I think there's another case I'll mention. The courts sort of focused on open and obvious, and I think that's where they got hung up, is, yes, it was open and obvious that there wasn't a handrail. Mr. Franz didn't appreciate it. He never had a problem or a near accident before. On the other hand, Mr. Funes admits in his deposition, no, I did not bother to look at the building code. He got a permit, so I applaud him for that, but he did not pay any attention to the building code, which would be very important for any builder that's going to rent something to the public. In any event, the Daniels case was also discussed. This is an open and obvious. It's in the reply brief. And this was a case where the lady's son the plaintiff's son was remodeling, and there had always been a handrail at a particular location. He had removed it during the remodeling process, but the court, in reversing the summary judgment, found that he should have either warned or put a handrail back up before he let other people in there. And the Supreme Court went on to say, the liability, her case may be razor thin, but it is not for the court to determine these facts. It's for the jury to apply comparative fault. And if you notice in our brief, the comparative fault arguments that we made went completely ignored or unanswered by the defendant. So we contend that they don't have an argument on comparative fault. And in fact, there's absolutely nothing in the record, which is why it's troubling to me about this ruling. There is zero in the record that Mr. Franz was negligent or in any way caused this accident or contributed even to it. So for all these reasons, we believe that the summary judgment decision was inappropriate, it's not justified, and we ask the court to remand this matter for trial. And I don't reserve, but my co-counsel has the other.
Thank you. You have the time for rebuttal. Yes, you reserve, you'll have 5 minutes for rebuttal.
Okay.
Okay. We'll hear from the appellee.
Your Honors, here is the stairway that we're talking about. As we can see, there are walls to the left and to the right of the stairs. The critical fact here is that he didn't reach for a handrail. He didn't reach for either wall. He didn't reach for anything. He just reached for the ceiling. That was his instinct when he started.
Well, why would he reach for a handrail he knew wasn't there?
Your Honors, the critical fact is that this was his instinct. The plaintiff in Wolf reached for a handrail. The plaintiff in these other cases reached for a handrail.
So he should have, and the trial court found that was important, that he didn't reach for a handrail that wasn't there. I'm trying to figure out if he knew the handrail wasn't there, and you say that's one of the reasons for comparative fault, that he knew it wasn't there, that since he didn't reach for the non-existing handrail, the absence of the handrail was immaterial.
Well, it's immaterial to the extent that
summary?
there has to be a nexus between the defect and the cause of the fall.
Well, how about, let me ask you this then on that, thank you. The plaintiff had an expert who testified that if the handrail had been there, it would have helped, I think the language he used was arrest the fall. Is that correct?
Well, I don't know what the expert's drawing that from. Certainly a handrail can be.
My question, though, was that what the expert said?
That may have been what the expert said, but that's not based on any of the depositions that have been taken. That's not the expert. There's no showing the expert considered the plaintiff's deposition testimony when the plaintiff said, I reached for the ceiling instead of the rail.
The rail that wasn't there.
The rail was not there.
Okay, go ahead.
The rail was not there. But just showing a defect, as the cases we've cited showing, isn't enough. You have to show that defect had some causal relation to the fall.
Well, this went off on summary judgment, correct?
That's correct.
And the plaintiff presented an expert that, as far as I could see, was unrefuted. East Tennessee allergies. That said, if the handrail had been there, it would have helped arrest the fall. So maybe the missing handrail didn't start the fall, but didn't the expert say that if the handrail had been there, it would have, at least was a possibility that it would have helped arrest the fall, stop the fall?
Your Honor, I guess we can agree to disagree. I read that as more of a general statement that handrails are there to stop falls. I don't read that as the expert taking consideration the plaintiff's testimony when he said, I reached for the ceiling. If a plaintiff's not going to reach for the rail, it's not going to work.
I understand, but there's no rail there to reach for.
There isn't, but there's two walls there. There's a wall to the left and to the right. Mm-hmm. And the plaintiff's instinct was not to reach for either wall or a handrail. If the plaintiff had testified that I reached for a handrail and it wasn't there, or I reached for a wall and gosh, if there had been a handrail there, it may have helped me. We have this testimony in the Overton case that plaintiff's counsel has cited. Here's a little bit different. In the Overton case, it's a wide stairway, so wide that the code requires a rail to be down the middle. In that case, there's positive testimony from the plaintiff that had a rail been there, something that she could have grabbed. Here we have no positive testimony. We have no deposition. We have no affidavit. We have nothing from the plaintiff at all saying that had a rail been there, I would have used it, or my instinct would have been different. And here we're going to
You
allow
have
a
an
jury.
you have an expert testifying that.
There's no
Wait,
showing-
Wait, counsel, I just want to get you to answer this question. And you've kind of danced around it 2 or 3 times. The plaintiff had an expert that was unrefuted at summary judgment. And keep in mind, this is a summary judgment stage, not a trial. At summary judgment stage, that the expert said if the handrail had been there, it would have assisted in arresting the fall. That was before the trial court, correct?
That's correct, but that opinion was prior, and Your Honors, we'll have to look at the technical records, I don't have the comparison here.
I
before me.
understand.
But I believe that opinion was given prior to the plaintiff's sworn testimony.
Well,
So
I'm still-
obviously, that was not taken into consideration by the expert.
I will tell you, counsel, I'm having trouble understanding how the fact that the plaintiff didn't reach for a rail that the plaintiff knew wasn't there, shows that the plaintiff would not have reached for the rail if the plaintiff had been there. And it's a summary judgment again. You know, at trial, who knows?
Well, that's true, but in every single one of these cases, every single one of these handrail cases, the plaintiff there's positive testimony from the plaintiff saying it would have made a difference. I would have reached it. I reached for the wall and there was no handrail there. I expected a handrail to be present and it wasn't there. There's nothing from the plaintiff in this case, nothing at all to that effect, none.
Except from the plaintiff's expert.
But the plaintiff's expert can't
Okay,
testify on behalf of the plaintiff.
We've gone round and round. I understand your position on it, and I think it's a great trial argument. I'm not sure it's that, to me, that it's that decisive at a motion for summary judgment stage. Go ahead.
Well, to speak to the expert, we have no problem with Todd Duncan. Todd Duncan's an excellent expert. He's an excellent expert for what a code provides for. He's an excellent expert as to how something's constructed or whether it's constructed properly or not. What he's not identified as is a biomechanical expert and how he can give an opinion as to how a person should or would or could react to a situation. There's no qualification for him to give that type of opinion. So I would distinguish that as well on that basis. He's a physical engineer, not a biomechanical expert. We think,
Any dispute that this was a code violation?
no, Your Honor.
Okay. Go ahead.
The fact the plaintiff lived in this unit for 5 months, traversed these stairs on a daily basis, is critical. Never said a word about it to the landlord. Never complained about it. Never had a problem with it. This plaintiff was fully and intimately aware with the condition of the stairs and the fact that there was no handrail. That is a critical fact. There's no case cited in here where you have a plaintiff with this level of intimacy of knowledge with a condition where the defendant was held liable. There's not any. Based on that fact, based on those circumstances, the court found dismissal was valid on several bases. One, that these cases didn't apply in this instance because of the intimacy of knowledge of the plaintiff of the defect, and 2, on causation. The plaintiff reached for the ceiling. He didn't reach for a rail. And we're going to allow a jury to speculate that had a handrail been present, his instincts would have been different. And that's when you get into this domino theory. His instincts somehow would have changed. And that's wild speculation, and that's something this court has repeatedly said we don't want the jury to engage in. So for those reasons, we ask the trial court be sustained. Thank you.
Thank you, counsel. Here for the appellate rebuttal.
As a matter of policy and a statement of social values, the law requires and utilizes the safety rules of the IRC for stairs. This is totally in keeping with our law. The risk of harm is clear. It's certainly foreseeable that someone could lose their balance on a set of steps like this.
Equally as foreseeable to your client.
It's foreseeable, but was it appreciated? And that just seeing that there's no rail with your eyes is not the same as understanding and appreciating the risk. And even when it is seen, if the circumstances are such that the property owner can expect they will encounter it anyway, then the duty is still on the property owner to correct the defect. And if this is the only way to get from one floor of your home to another floor of your home, it is certainly to be anticipated you're going to use these stairs, whether there's a rail or not, to get up and down. And it's, you know, there's a rail to here, and there's these walls on each side. I believe in one of the cases, I think it was one where the woman was going down the stairs of the bank, she reached for a wall, okay, but there was nothing there. Here we have the incongruity of saying that, as he was arguing, the court was correct that the cases didn't apply because the plaintiff was so familiar with the defect. He knew there was no rail at the top. And then in the next breath say, and for causation, because he didn't reach for the rail that wasn't there, that he knew wasn't there, but for 5 months he knew wasn't there. Instead, he reached for what he hoped he could reach, the ceiling, to stop himself. Okay, but he couldn't reach it. There's a like lower little ceiling there. He couldn't reach it. So it's incongruous to say he can't, there's no duty to him because he could see it wasn't there and use the steps for 5 months. The fact that he didn't complain, he didn't go out and buy a rail himself, he didn't say anything to the landlord, is actually evidence from which it can be inferred he did not appreciate the danger. Mr. Funes did not appreciate the danger. I believe the testimony was a relative of his, I think his mother, that lived in this house before when he built it. He did not know the rail was required. He did not know until he was sued by Mr. Franz that he had this duty, but the law requires him to know and comply with that duty. The risk of harm is clear. It's certainly foreseeable that someone can fall down the steps. The gravity of harm is great. You fall down 14 steps to a floor below, you could be killed or seriously injured, as Mr. Franz was. The burden on the builder is minimal. You know, go buy a ready-made handrail and screw it to the wall. And the importance of compliance with the IRC is clearly articulated by the punishment penalty that is imposed of up to $50 a day for each day the defective condition is present. So I have trouble with the fact the trial court nor the defendant has given any testimony in this record or any evidence as to why Mr. Funes should be relieved of his duty, his lawful duty to provide this safeguard, and why Mr. Franz is charged with some superior knowledge just because you can see with your eyes that there's no handrail. But if you don't appreciate the danger, that's what matters, is appreciating the danger. And if you're required to go up and down those steps, even if you fleetingly thought of it, you may forget it, or you may think, well, it's okay, go up and down. You know, house has been here for a long time. It is hard to, in this weighing balance of duties, Mr. Funes is charged by law with knowing this danger and protecting against it.
Your time's up, counsel. Right.
Okay, well, if I can just say one sentence.
Yes, you can.
Mr. Franz went 5 months with this. Mr. Funes went 11 years with this defective condition.
Okay. Thank you. Court's thanks to counsel for both sides. We appreciate your arguments this morning and your briefs. So you may go.
By any chance, do y'all want this one that's got better light than what's in the record? The one in the record is little.
No.
Okay, all right, just thought I would ask. This is my homemade poster.
Call the next case, please.
Jerry McBride individually and DBA The Real Estate Shop versus Cynthia H. Allison.